Viewers, welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of over 30 years' experience. With me tonight, I've got a partner in the law firm in compensation, John Karantzis.
Hi, Tony. Hi, viewers. Hi, Viv.
And also a former lawyer, come marketing guru, Vivian Ryan. Good evening, Viv.
Hi, Tony. John, viewers, good evening.
Tonight, viewers, we've got a riveting episode on mooting, which is mock trials. It's a great way of working out what happens in a real trial. So stay tuned. A must-see episode.
However, before we get to that, Tony, what's in the news?
Well, John, this is right up your alley.
Oh, yes.
The first story is the Essendon one. Judge Middleton absolutely slammed the Essendon Footy Club. What does that mean for the club, John?
Tony, it means the club has a limited period of time to appeal. They've been ordered to pay costs, which could amount to at least $2 million, Tony. ASADA has been vindicated. All the investigations between ASADA and the AFL have been vindicated. It's all okay. But
more importantly, what it means, John, is that a lot of the players, their contracts are now void.
There's question marks about conduct, and that is crucial in all these contracts. And Tony, it may open up the door for every player to have a civil action against the Essendon Football Club.
At this stage, it's too early to know what effect the drugs might have on the players. But no doubt, down the track, if they've got more than one player's got side effects from these drugs, you'd think they'd have claims, wouldn't they?
Open up a floodgate. So let's watch this space.
Oh, yes.
Yeah, I think so. Look, we'll come back to that, viewers, so please stay tuned. Viv, tell us a bit about this claim involving the school teacher, stress claim, 1.3 million. Big case.
This is a case about a teacher who was awarded $1.3 million in compensation. He's a teacher who is out in the western suburbs in Victoria who suffered chronic depression as a result of his constant subject to what they're classified as feral children. This school is renowned for its now streaming process, so they actually stream the children into sort of different grades, and unfortunately over a 6-year period he was subjected to some really, really awful environments with these sort of lower academically classed children. So I really feel sorry for this guy. Now it opens the floodgates up to other schools, really.
John, this conduct, it's been going on for some time. Does it open up the floodgates to other claims by teachers against other schools?
It may, Tony. The key to this case was, Tony, he made repeated complaints about the position he was required to perform. He was required to teach these feral students. He was under constant pressure for years. The school and the Department of Education didn't do anything about his position. They knew he was suffering. He was suffering extensively. He suffered a nervous breakdown, Tony, and now he's received $1.3 million in compensation in damages for pain and suffering, past and future economic loss, all because the system didn't hear what he was saying. And this is the key, Tony.
The thing I'm happy about, guys, is that at least it's starting to open the door for psychiatric injuries, because in the past they've been looked at, you know, in a different light.
Exactly. So just on that, what sorts of things would he have had to prove in the court for viewers who perhaps might be sitting at home wondering whether or not they might have a case?
On the balance of probabilities, was the conduct in question damaging to him psychologically? And secondly, did he make complaints about it to his employer? If he didn't make any complaints, he would have lost his case. But here he made repeated complaints and they were ignored by the employer.
And he would have also had a serious injury under the definition of serious injury for psychiatric injuries, which is a long-term impairment.
They also speak here about reasonable foreseeability, and, you know, arguably in this particular matter, it was reasonably foreseeable that he was constantly exposed to these particular children.
But he was complaining on a regular basis, so the foreseeability argument goes out the door, Viv.
Exactly.
You know what I mean? Let's keep moving. James Hardy are running out of money, Viv. Can you believe it?
Oh, this is incredible. The asbestos fund that's been set up for those asbestos sufferers has now moved into a different payment scheme. So they're paying in instalments rather than...
Instalments?
Yeah.
Instalments?
Yeah.
So someone's dying, they're getting paid in instalments?
Yes.
And
sorry, do you die in instalments?
Well, that's the point that
that's
this...
No, you don't, do you? It's crazy.
No, yeah, so... but interestingly, while there's a shortfall, they were still able to pay...
massive dividends.
Correct, so...
Surprise, surprise.
Yeah, there.
I think there's going to be a lot of pressure to bear on James Hardy.
There should be.
It's going to be a situation where they're going to have to put more money into this fund.
There should be.
The government's going to have to intervene because there are a number of claims that are coming out of the woodwork. I mean, we're talking
And it's
about
increasing.
housewives,
It's increasing,
children,
isn't it, Tony?
Yes, not only workers, but what about children and housewives?
Oh, it's
just
incredible.
bizarre.
Yeah.
I mean, you know, it's a situation where
Who actually governs this particular scheme? Do you guys know?
it is governed by.
The Commonwealth set the scheme up.
Set it up, yes.
But of
in
course,
consultation with James Hardy.
exactly.
Thanks for coming on board as usual.
Thank you.
You'll stay tuned. After the break, we'll be talking about mooting. Viewers, welcome back to the show. We're going to be talking about mooting. But before that, we've got Steve Notarianni, an experienced compensation lawyer in a law firm. Good evening, Steve.
Thanks, Tony. Good to be here.
Now, John, mooting, what does it mean in short?
Tony, moot, it's a mock trial held by students at mainly a university. There's judges there. It's in public. It's a mock trial, Tony.
Now, the judges are made up of who?
It could be judges literally acting outside of the course of their normal workplace. It could be experienced lawyers, experienced teachers, anyone that's really experienced in the field of law.
And in this case, the video clips we're going to show the public, we acted as the judges.
Exactly.
Steve, give us the facts of this particular case where we're going to be seeing some video.
Yep. Look, a brief summary of the facts in this case. Look, the worker involved was a qualified electrician who operated his own company with his brother. They contracted exclusively to a company called Commercial Sparks. Commercial Sparks, in turn, had sent...
Can I stop you for a minute? This is a real case.
It is based around a real
Real
case, Tony.
case, yes.
It is, yes. Commercial Sparks sent the worker involved to the premises of a third party to perform some electrical contracting work. In the course of performing that work, the worker came into contact with an exposed cable, suffered an electrocution and a resultant injury to the back.
John, one of the first things that we did in this particular moot was there was this big argument about whether the actual worker was a worker
at law and employed by Commercial Sparks. Yes, that
and what
was
were the
crucial.
issues that come out in that?
Well, the issues, Tony, were here. The individual worker that was injured here, he was a subcontractor, and he ran his own show, his own business. Now, the question for the mute students was, well, is he an employee of his own business, or was he an employee of Commercial Sparks?
Steve, just because you're a subby, at law you can still be a deemed worker. What does that mean?
That's right, you certainly can, Tony. The totality of the employment arrangement needs to be examined in order to determine whether you can be a deemed employee. And one of the major issues there is whether you're working exclusively for one entity or certainly performing at least 80% of work for one entity, which in this case was taking place. The worker in question was performing work exclusively for Commercial Sparks. Viewers,
let's go to this small footage of the moot at RMIT, which involved a number of students from different universities.
The respondent and his brother own the business Oversight Electrics, and Mr. Joseph does not work as an employee but as a representative of Oversight Electrics.
Counsel, how do you get around the factual metrics that the respondent did not perform work for any other business or organisation?
I'm relying on the fact that there was nothing in his contractual arrangement which prevented him from performing work for any other organisation, and also on the fact that in establishing Oversight Electrics, this was deliberately altering the previous arrangements between Mr. Joseph and Commercial Sparks. And if he had wished to continue in that arrangement where he was working solely for Commercial Sparks, there would have been reason to keep it in place when apparently there wasn't.
So the facts of this case is working exclusively for commercial sparks.
Yes.
What are the facts of the case that makes the respondent a worker, a deemed worker?
Okay, so the facts of the case are that the respondent was employed by Sparks Engineering, and basically he was offered a uniform to wear as part of his job in his capacity as a worker, and in that capacity as a worker he also wore specific gloves provided by Sparks, and he also was asked to be a supervisor of the workers provided by Sparks at the time. So the law regarding being a worker under Section 5A is that he is performing the work for an employer.
Now, John, you've seen the footage. What do you make of that?
Well, Tony, as you know, at the hearing of this trial, I found that he was a worker.
What did you find, Steve?
I was in agreement with John. I found that he was a worker for the purpose of the act.
So we got to the next stage of the matter, which was whether there was a duty of care. Viewers, I found that he wasn't a worker because he was an independent contractor with specialised skills. Let's go to the next point. Once you establish he's a worker, you've got to look at the issue of whether the applicant, that is a worker, was owed a duty of care by Commercial Sparks. Now, what does that entail, John?
Well, Tony, the respondent must prove on the balance of probabilities that Commercial Sparks owed him a duty of care, as in he was owed duties in regards to his safety at the work.
Okay. Now, Steve, what are some of the things the court looked at in terms of establishing whether there was a duty of care owed?
Yes, well, first of all, I think once it's established that he is an employee, that there is a duty of care owed by Commercial Sparks, and things such as have they conducted a proper risk assessment of the workplace that they're sending the worker to, have they provided appropriate equipment for his safety in conducting his duties. Issues such as those arise as to whether they've discharged their duty of care.
Okay. Now, the thing is, being the independent contractor that he was, this issue of whether they owed a duty of care kicks in again, doesn't it?
It certainly does, Tony. He's a qualified contractor with a particular expertise as an electrician, and the employer is entitled to rely upon that expertise in, sending him out to premises to perform work.
So the argument being that he, the worker himself, had duties as to safety and as to conducting an appropriate safety check.
Exactly.
Exactly right.
I think the thing that helps this particular worker, John, is the fact that Commercial Sparks supplied him with the gloves.
Oh, yes.
And, you know, they weren't the right gloves, were they, Steve?
That's right, Tony. Commercial Sparks provided the worker with leather gloves to use on the job, and ultimately it was those gloves that were the cause of him suffering the electrocution.
If he had the appropriate gloves, he wouldn't have got electrocuted in the first place, would he?
That's one of the key issues, that's right. There's evidence to suggest that if he was wearing proper rubber gloves, those gloves would not have conducted the electricity and he therefore wouldn't have suffered the electrocution.
He should have his own equipment, and as you know, most experienced subbies do.
Okay. Now, viewers, we're going to take you a segment of the moot that was conducted at RMIT on this particular issue.
Is it fair to say on your submission that you've considered the point about employee-employee relationship?
No, Your Honour. Rather, I'm saying that if Your Honours were to find that there was a relationship, then even if such a relationship were to hold, then that relationship was fulfilled, the duty was fulfilled, and in this sense, no onus should be held upon the appellant. So, in a sense, we're covering a contra in this sense.
Isn't your position problematic if we do not find that Mr. Joseph's a worker, a deemed worker?
It is problematic, however, we are submitting that he is a worker.
But assuming he's not.
Assuming he's not. Yes.
And
I will concede that it is problematic if it's found that he's not a worker, due to the fact that there is a difficulty in establishing the duty of care exists.
Steve, just quickly, what did we find in that particular segment?
Look, in our moot, Tony, we found that he was a worker, that there was a duty of and that there was a duty of care owed to him by Commercial Sparks. Okay. Viewers, we've got to go to a sponsors break, but after the break, stay tuned because we're going to look at whether Commercial Sparks caused the workers injuries and further
what contribution did the worker have to his own injuries, and we'll give you the result. So please stay tuned. Viewers, welcome back to the show. We're still talking about this case of Commercial Sparks. Now, the next important issue, John, is did the employer cause the workers injuries? What are some of the things that the court looks at in this regard?
In this regard, Tony, Commercial Sparks, it was argued that they had control of this workplace. They were responsible for this workplace. They were responsible for the safety checks of this workplace. And as a result, or lack thereof, of not performing their required duties, the employer caused the injuries to the worker.
Steve, on that issue there, what are some of the things that the court looked at to determine whether there was a breach?
Yeah, things such as I mentioned before, Tony, regarding proper risk assessments in relation to the workplace. Had they conducted those assessments? Had the Commercial Sparks provided proper safety equipment, inclusive of the gloves, which obviously were a key issue in this matter?
How's it possible that you employ someone with expertise that, is pretty, it's something that you and I couldn't possibly give advice about?
Yes.
How could, there be a breach if he knows the pitfalls of doing his job? And also, Steve, let's have a look at this issue about the gloves, right? The employer gives him the inappropriate gloves. He's been an electrician for over 20 years. I mean, surely he must know he shouldn't be wearing it.
That's right, and I think that's going to go to the issue of contributory negligence, which I think we'll move to shortly. That's right. But I think once it's established that he is an employee of Commercial Sparks, that they do owe some duty of care, and they will be found liable to some degree, but that can be mitigated with regards to the issue of contributory negligence.
Isn't it fair to say that even if the worker succeeds in arguing that there's a breach, that it could turn around and he's going to get nothing because the court could say that his own contribution was 100%?
It could.
Yes, that's entirely possible, Tony.
All right.
So even more so in a case like this where the injured worker has this particular area of expertise and is such a specialised area.
Viewers, let's go to that segment that talks about this particular issue at RMIT.
And that was to the extent which we submit the duty of care of the appellant should have been in this case. Since the appellant was not physically on site and couldn't know the exact nature of the issue at hand, and all that they could understand was what was relayed by the respondent and the client themselves. And in this sense, it was reasonable that once those job assessments or risk assessments were made, it was solely up to the respondent to undertake that task and undertake a certain method associated with that task.
You've touched on the issue of the provision of protective equipment by the employer to the worker. Is it the appellant's position that the leather gloves provided were sufficient and proper protective gloves for
Absolutely, because in this case, it has not been. It does not seem to be the case that the gloves themselves were malfunctioning, but rather the respondent himself came into contact with an exposed wire, and from that contact he was electrocuted and fell down onto the floor from a ladder, and from that he suffered spinal injuries.
What do you say caused these injuries in this case?
What caused his injuries was the electricity and the overall unsafe working practices that have been created.
What in particular about electricity caused these injuries? How did he come into contact? Was it his body? Was it his hands? Do we know? Can we infer anything from the facts?
From the facts, it is not specific as to what part of his body made contact. However, given the nature that he was pulling a cable, it would indicate that it was his hands that touched the live wire, and that speaks to the unsafe work practices more broadly that were created by the appellant. The appellant was responsible for those work practices, and that was where the issue, as Your Honour raised earlier, of the gloves, which were deficient.
Now, viewers, in that segment there, what I found really astounding was that none of the students, and a lot of bright students in those moots, picked up on the issue of causation. That is, factual and legal causation, which I found astounding, Steve. I mean, the factual part of it is when you're talking about what was it factually that caused the injuries.
Yes.
And the legal causation is there an obligation on the part of the employer to protect someone with this expertise in these circumstances? That is the expertise being a legally qualified electrician.
Oh yes, in particular the issue of the employer being in control of this workplace and the worker having the relevant expertise and again being in control of his own work duties.
Exactly. Now Steve, let's go to the last point. Assuming that we found that the employer had breached their duty of care to the worker, then the court has to look at the issue of what contribution did the worker have in relation to causing the injuries? What part did he play?
Yes, well, look, in the circumstances of this case, the argument was that the worker has played a very significant part in sustaining his own injury because of the fact that he had the particular expertise in the electrical field, and even despite that expertise, he decided to wear the leather gloves, which was ultimately got sweaty and conducted electricity and resulted in the electric shock. With that expertise, the argument is that he should have known better and should have used the rubber gloves, which would not have caused the injury.
Now, John, just on that issue of the gloves, the fact that he's qualified and the employer has given him the wrong gloves, what should he have done?
Well, that's the argument. One school of thought was, well, he should have said, sorry, I can't do this job until I am provided with the appropriate and correct equipment.
But why? He's the subby. Why didn't he bring the equipment himself?
Well, exactly, and that's the other school of thought that, you are employed as a subcontractor to perform this specialised work. You are required to bring your own specialised tools.
I want to go to the footage in relation to this now because I want to talk about it afterwards as to what the result was. So viewers, let's go to this footage that deals with this issue of contribution by the worker.
So you're saying there's a full defence?
Pardon? There is a full defence, as stipulated under the Wrongs Act, yes.
So if we don't agree with that, what apportionment would you make in this case?
If there were a portion, we would probably suggest it be as minimal as possible, but that is up to discretion of the court.
What apportionment would you make?
We would probably make an apportion of 20% towards the appellant.
If the bench finds that the respondent is not a worker, what is your alternative position?
The case is that, as Your Honour's rightly pointed out, individual contractor is not owed a duty of care by a primary contractor, and such duty would be a very low duty. However, where we submit that there is a duty is that Commercial Sparks provided protective equipment, they provided a work process and procedures, and they have to ensure that the services they provided were safe. We are submitting that those procedures were deficient and that caused the accident. If they had not provided procedures at all, then they would not be negligent. They would not be breaching their duty of care. But because they provided that, they needed to ensure what they provided was safe, and what they provided was not.
Now, John, what were your findings in relation to this case overall?
Oh, Tony, I found that he was a worker, that a duty of care was owed to him and breached by the employer. However, I found that there was contributory negligence.
Steve, can you recall what you found?
Yes, Tony, I certainly was of the view that he was a worker, that Commercial Sparks owed a duty of care to him, and that duty of care was breached to some degree, but was very heavily mitigated by the worker's own contributory negligence, which would have or should have resulted in a significant reduction in the amount of any damages awarded.
All right. My recollection of what happened was I found that he was a worker, so as not to demoralise the team, the losing team. I found that there was a duty of care, that there was a breach and high contribution. My recollection is we found 50-50 for the worker job. I was not as damaging to the worker, but in any event, that's my nature. All right. But Steve, in reality, what happened in the Court of Appeal? Tony, in the indemnity recovery proceeding?
Yes, in the Court of Appeal, WorkSafe ran a recovery proceeding against the occupier of the premises on which the worker was injured, and they failed in that proceeding before the court.
Okay. Now the occupier, who's that?
The occupier being the third party. In the circumstances of the moot, the occupier was a company called Waterfront, but they were the occupier of the premises on which the electrical work was being performed and where the worker sustained injury.
And John, a lot of the evidence about this recovery proceeding was the worker himself giving evidence about what transpired, correct?
Exactly, and the nature of his duties and what was required.
Okay. So, look, stay tuned for future episodes. Go to our website, go to our past episodes, and always remember to stay safe.